Good afternoon, folks. It's 1 o'clock and we'll reconvene this meeting here today. Corey, would you please do a roll call?
Commissioner Schroeder?
Here.
Commissioner Buck?
Here.
Commissioner McDaniel?
Here. All right, thank you. The first item on the agenda is the continued from June 11th, 2025 is a Running Creek RV Storage EDZ 2024-3548. Is there a motion to open this hearing?
Sure, I'll make a motion. We open the hearing for Running Creek RV Storage, EDZ 2024-3548.
Second.
All in favor, aye?
Aye.
Aye.
Aye. CJ, you've just got a letter from the county regarding findings that the county went out and tried to get an independent study on that particular area. So I'll make you an offer. I don't know if they've contacted you yet. We just got that late yesterday. So
Yeah, correct. I got it at 4:45. We've,
so if you want to continue, we can do that. Or if you want to go forward, it's strictly up to you.
we do not want a continuation.
Understood.
This is
Okay.
the third BOCC hearing. So
Understood.
what we'd like to do, if it's okay with you, our traffic engineer, Dave Rubel, is here. He's, even though it was last minute, he spent a lot of time looking at that accident investigator letter. You know, we'd like to have him speak a little bit on behalf of it. Then I'd like to come back up and follow him, as well as probably John Goudreau, the owner. So if that's okay?
I'm good with that.
Okay, thank you.
Good afternoon. My name is Dave Rubel. I've been doing traffic studies for 26 years in Colorado. I worked for a consultant for about 10 years, 1999 to 2009. I then, when the economy tanked, I formed my own company, and I've been doing traffic studies for the rest of my life, it seems like. When I'm hired to do a traffic study, I'm paid by the developer, but I'm hired to be an independent third-party evaluation of the project and to advise both the client and the county or the city where the project is located on how to mitigate the impacts of their project. I'm just a third party. I'm not biased for the city or the developer. I'm doing an independent analysis. I don't really render a value of the project. It could be a toxic landfill for all I know, and I just tell them, here's the impacts and here's what you do to mitigate the traffic. There may be other impacts you have to mitigate, but I'm just talking about traffic. When you talk about the need for auxiliary traffic lanes, it is solely based on the traffic entering and leaving that access. It's not based on whether you have 100 cars passing that access or 10,000 cars passing that access. That is not the way it's done in Colorado, and I'm talking from the perspective of the State Highway Access Code, which was developed in 1998, amended in 2002. It's used by CDOT for all their state highways. A lot of cities and counties use that as a default because it is, in my view, the gold standard for determining auxiliary traffic lane requirements. It is not based on the number of cars going past that access. The thresholds in the access code vary depending on the classification of that roadway. Rural areas, they have two access codes, RA and RB. County Road 13 qualifies as an RB according to the classification of the roadway that's in the latest master traffic study. It's based on the peak hour traffic. In most cases, that's a weekday. In this case, RV parks usually have a peak on the weekend. People driving in to pick their RV up to go camping. You know, a person that's versed in accident investigation, I don't think has a right to be rendering a decision on this project. I'm not aware of any county in the state that uses safety as a basis for determining auxiliary traffic lanes. What happens, though, access does play a role, is that if you approve the access and you meets all the design standards and you discover a problem with that access, there's a high accident rate for left turners turning out of that access. You as a county have the right to go in to deny that left turn out movement and restrict it to a 3/4. You can even restrict it to a right in, right out if you feel there's a safety problem, but it has to be an actual problem, not a theoretical problem created by somebody that has no business evaluating this project from a traffic standpoint. I don't think Elbert County can use the information in this report prepared by Mr. Smith in making any decisions. Safety carries no weight in how you evaluate this project. It carries weight in how you design the project, but there's no weight in whether or not you grant or you don't grant this access. I think it's wrong to use this report in any regards. I've got copies of, I did a more detailed evaluation, which I'll hand out, and I'll hand out copies of my prepared statements. Who do I give those to?
You can bring them up here.
Okay.
Give them to our attorney.
I'll be glad to answer any questions you have. I've done about 20 projects in Elbert County alone. I've done pet cemeteries. I've done 1,600-acre developments around DIA. I've done the full gamut. I did the Broncos, Del Valley Business Park where the Broncos are located. I've done numerous residential developments. I have a wide range of experience that I bring to this subject, and I think you have to base it on the merits of the threshold values in the State Highway Access Code. Those really are the ones that should determine how you judge this project and what you require this project to do in the way of mitigating the impacts of the project.
Okay. Commissioner Schroeder, do you have any questions for this gentleman? All right. Commissioner Buck, do you have any questions for this gentleman?
I would like to touch a few points in the.
Give me just a second, if you don't mind.
Okay.
Do you have any questions for this gentleman, sir? I do. Okay. Let him do his questions, and we'll come back.
Okay, sure. Thank you.
Commissioners, for the record, I've been given 2 documents, 3 copies of each, so I've numbered them at the top right. Either document 1 or document 2. If both of you could please keep your copy after the hearing so we have a copy for the record. We will need to submit that so we have a record of what was submitted, but that's for your use today.
Okay, thank you.
Yeah, so I did have just some clarification questions.
Sure.
Part of your statement, you said that it was not based on traffic count. It could be 400 cars or 4,000 cars or what, I don't remember the exact numbers you used, but they're not based on traffic count, but it is based on peak traffic count. Can you, or I don't remember exactly how you.
Peak traffic entering and leaving the site, not the peak traffic on the highway that doesn't use the access.
Gotcha. Okay, so I wanted clarification on that.
Sure.
I appreciate that. Not based on traffic count is something new to me that I would think traffic count would be relevant, but.
Again, it's only relevant, and I'll give you an example. You could have, I just did a Groove Subaru dealership. They had 20 cars entering the development. They had a horrible level of service because they could not find a gap in traffic. So that information is used to design, yes.
Okay, so that kind
And
of
restrict the access.
that kind of goes to my next comment, which you had made in regards to safety. Safety has no bearing whether we allow access to this property. Now, we're not trying to say we want to deny access. We are looking at safety as a concern as far as the design is concerned, as far as a left turn lane or a, acceleration or deceleration lane, and those are design features. So we're not saying we want to deny access. We're saying we're looking at the design from a safety perspective. And in my book, and I think the other board members, if I can speak for them, that safety is a concern for them as well. With that high school there, I previously hadn't thought of the drivers from the high school. I had taken into consideration the bus traffic. There's a middle school there as well. We got buses, we got some large vehicles going down that road, but I hadn't even thought about the quality or the inexperience of some of those drivers until recently. So those were my comments or questions, but go ahead.
Mr. Schroeder, anything?
Well, I don't see how we penalize an applicant for where they happen to be located next to a school or down the road from a school. I've driven that road several times now since this has been before us, and there's a long line of sight, both northbound and southbound. And I am questioning in this letter we just received this week how that would play in. There's a lot of supposition, a lot of guesswork in this letter, and I don't see where we have the expertise in this letter as we do before us.
Okay. And I'd just like to comment too. I get what both of you are saying, and I get what you're saying. But we do have a high school there with young, unexperienced drivers there. We have a middle school, we have buses, and there's an issue with the sight distance coming over that hill. I've worked many wrecks, many fatalities in my career. I don't want to not honor the property rights of the individual that's trying to do this. At the same time, I think we have a responsibility here to make sure that our kids out here on the road are safe. And I'm concerned about vehicles slowly turning in after they come over that hill. And I think you'll agree. Do you agree there's a sight difference or sight distance issue there?
It meets the standards for having an access at that location based on the speed limit.
Well, I think that's what we were just trying to find out, because we've talked to different people and everybody's got a different opinion.
There are a lot of opinions. There's 4 million traffic engineers in Colorado, trust me.
Right.
And they drive a car, so.
So, this is a big deal. It's about, and it is, whether you think so or not, it is about the safety of our kids and taking care of that. Teenagers and young kids on school buses, things like that. So that was my point about it. And but I appreciate your opinion and thank you for submitting this. So that's the only comments I have. And I think you had some other comments you wanted to make.
Yeah, some other ones. And I'll use 13. The last master traffic study that Elbert County did said there were no improvements needed to County Road 13. It was adequate. The only improvement you identified in your report was the repaving of 13. So your own consultant didn't identify that there was a safety issue on the highway in the way of design. So I don't think there's a safety issue on 13. The drivers is a separate issue. You cannot design for every situation out there. You design for the typical condition. In this case, the typical weekday condition is one vehicle turning into the site and one vehicle turning out of the site. That's the weekday. On the weekend, it goes to 3. 3 vehicles. You're asking this gentleman to invest a lot of money because of 3 vehicles. That is, I mean, we'd have a 16-lane freeway on I-25 if you designed it for the Bronco game. You don't do that. You design it for a typical condition. So I'd just like to make that point. Mr. Smith uses I've never seen this term used anywhere in the reports I've done or have seen. He says the right turn passing sight distance. I have no idea what that means. If he's talking about a car slowing down to make the right turn and the other vehicle swerves around that vehicle to pass it, he just needs to slow down and do what's right. He just needs to slow down, let the vehicle make its right turn, speed back up. Crash density was a really a good one. He said that there's a lot of high crash density along 13 and 86. That's where all the traffic is. You expect to have higher accidents on a traffic road that has 18,000 cars on it than has 100 cars on it. So what he should have done was look at the crash rate. What's the crash rate for the county as a whole, and what's the crash rate for 13 compared to that average? That's really what he should have done. So crash density is, I've never seen that term used before. He really never provided any justifications or recommendation. He said it's widely unsafe. Your own traffic report didn't, or master traffic study didn't say it was unsafe. It's level service A to B, A to C, I think is the standard, A to C. I would kill living in Denver to travel on a road during rush hour that's got a level service C. It just doesn't happen. So I think that you have a road that's A to C, that shouldn't pose a problem. He talked about the growth rates are extremely low. It's going to be a lot bigger than that. Well, your West Elbert County Transportation Study forecasted 18,000 cars on that road in 2008. Your update in 2021 lowered it to 10,000. That equates to about a 1.5 annual growth rate. 86 has an annual growth rate of about 1%. So it's very close to what I would expect to see on a county road that's feeding into a state highway. Again, I don't think it's under-designed. I think it's adequate for the traffic on it. Your standard says you get above 16,000 vehicles on it, you need to 4-lane it, I think was the number. You're at 5, going to go to 10. You know, it just doesn't make sense to me to make those kind of statements if you can't back them up with quantitative data. And that's why the access code is so important for a local government to use and make a decision, so you're not accused of being arbitrary and capricious about how you decide what to do and what the applicant's required to do. I think it makes your life a lot easier, and it makes the developers, it presents them a more predictable situation for them to know what they're going to have to make in way of improvements to their project. That level of uncertainty makes it very hard for people to make investment decisions. So I think using hard numbers like the access code tells him what he needs to do. He can look at that. I could tell him early on, this is what looks like you're going to be required to do, and then he can make a decision whether or not he wants to move forward with that investment. I looked at this and I said, you know, it should take about 2 minutes to make this decision. I just look at it and I'm boggled by what we're having to go through to get this project across the finish line. I mean, that's my opinion. I worked 30 years at CETA also, by the way, so I've been
We
in
appreciate your
transportation
opinion.
all my
Thank you.
life, basically, since I graduated, so.
Thank you for your opinion.
Sure.
Anything else you want to answer? CJ, anything else you need to answer?
Yeah, thank you, Dave. Yeah, so it's been a long road, and you know, we dealt with a handful of some different traffic engineers' analysis here. I don't think that Kimley Horn disagreed at all with the trip count that was generated from the site, which is basically one trip in the morning and one trip in the afternoon, this is during the weekday. As Dave mentioned, the CDOT access code states that on this type of road, at a minimum, you would need more than 10 peak trips before a left turn lane is required. We're at 1. Secondarily, you know, the concern that the site distance is an issue, that's been confirmed that it isn't an issue when you look at the criteria that you're supposed to look at. Because you have a school time frame that occurs during the middle of the week, which is presenting one trip in a peak hour for AM and PM, those two sort of uses really aren't going to be conflicting. The majority of the traffic is going in on the weekends. Schools aren't on the weekends. I would say if the county is really concerned about this, you know, reducing the speed limit would help immensely, because it increases from 35 to 50 in front of our, you know, property more or less, and a little further to the south. That could help, but you know, our engineers base their designs on criteria that either the county has, and where the county has holes in their criteria, in this case, they refer back to CDOT and the access code. All of that criteria has an immense amount of factor of safety in it. That's the way engineers are. That's the way their guidelines are created. They can't create guidelines that are right on the edge. Those factors of safety are there to create safety for the public. So it's not that we've ignored safety, we're just following the guidelines, the standards, the specifications that the industry puts out there. And because we've met that, and it was noted in that report from Kimley Horn, it was noted in the letter from Dale Gillians, the traffic, or the county engineer, indicating that we had met all this criteria. There was no improvements required. Everybody's in agreement that we were meeting criteria, yet we're here today talking about additional improvements that the criteria isn't requiring. So, you know, and I want to bring this up because we've got some new people here, but we have our initial meeting on May 28th. We have a recommendation from staff for approval. The normal conditions and one other condition, which has to do with an 8-foot fence, which if we were only dealing with that, we wouldn't be here. We have basically a continuation from that May 28th because all of a sudden this conversation about a left turn lane comes up. And we are continued to June 11th. We're presented a new letter from Kimley Horn and a second letter from the county. This time, instead of coming from Dale, it's coming from Monty. And they're now saying a left turn is warranted. There's nothing in either of those two revised letters that indicates why all of a sudden now it's warranted. The original letters indicated that we met all of the criteria. So we're here in front of you all again on June 11th, and we're talking about this left turn lane that now is warranted. And I bring up some question about whether you guys are thinking it's just a left turn lane, and all of a sudden, no, we think that this could also be, you know, an XL decel lane. And so I asked for some clarification. You guys wanted your staff to look at this and for us to meet with staff directly. That afternoon, I tried to set up a meeting with Jennifer. We have never had a meeting. And it's because we were told that a certain commissioner went out and got his own traffic letter, and we were waiting to get it. We got it yesterday at 4:45. It's prepared by somebody that investigates accidents. So, you know, this just doesn't, the way that this was handled, it just doesn't seem fair. My client has spent a lot of money getting everything designed to meet the standards and specifications, to the point that we got a recommendation of approval from staff. Yet here we are, third BOCC meeting. A little more than a month, probably more like 45 days total from the initial BOCC meeting. So, you know, we're not opposed to continuing to talk, but we feel like the target is constantly being moved. And the target was dead set when we came here before you on May 28th. Everybody agreed that we met all of your criteria. So, Mr. Goudreau is probably wanting to say a few words, but I think with all of this, it's pretty clear that, you know, an accident investigator, it's an apples and oranges sort of person to bring in at this point. We've got traffic engineers, civil traffic engineers that design things based on criteria and code, and that's what's occurred. And we just ask that because all of that was found to be compliant, that we get the same kind of motion for approval that was brought to you in the staff report on May 28th.
To your point, as you made in your statements there was different information in the very beginning. There was different opinions about that, and that's why we went out to try to find somebody who could give us an independent opinion. So we were a little confused with that just as well as you were. So I want to clarify that. And then the other thing,
I don't think we did have
Let me
any.
finish, please.
Okay?
The other thing is we have a safety issue that we're concerned about, especially with that school there. And we all have our opinions. I have mine. Everybody here has theirs. I do feel like there's a sight distance issue there. I'm not an engineer, but that's the way I feel about it. And sitting on this board, I have a responsibility to the citizens of Elbert County and to their children out here that are going back and forth to that school, and I'll just leave it there. There's still a lot of opinions, but what I've heard from this gentleman, David, just got up here, and it makes sense what he said to me, or what he has said to this board. And I appreciate him being here making his comments. So there's a lot to consider, but we're just not going to rubber stamp this just because you've been here 2 times or 3 times.
Okay. Well, I mean, it's not just a 45-day period. I mean, we've been involved in this and trying to get everything to a point where it's acceptable to all of the third-party consultants and your staff for probably 9 months or a little over, 15 months now. So it's been a lot longer than 45 days for us. There was absolutely nothing in that revised Kimley-Horn letter that Monty supported that showed any change from their original letter indicating that there were no improvements required. It was almost as if somebody said, we need you to now say it's required, but there wasn't any support for why are you changing your opinion. So there's not a lot of different opinions out there. The facts have been presented and the facts have stayed pretty consistent. Kimley-Horn reviewed Dave's letter. Dave's never written a revised letter. He's never changed his analysis, his data, ever. Yet Kimley-Horn gets to write a new letter without anything that supports that.
Did you request that letter to be written? I didn't request it. Did you request it?
The
Do we know?
Kimley-Horn letter?
Yeah.
Why would I request
Well, I'm
request
just
him to write a
asking
letter?
you. I didn't request it.
It was written for the county.
Okay. All right. Noted. Anything else you'd like to add, sir?
Just 1 second, please. June 3rd, Kimley-Horn writes a letter to Mr. Monty Hakens. This is the same identical letter that they wrote on March 25th, with the exception of the last sentence. Everything else, a 1.5-page letter is identical to the first letter. All of a sudden now they're basically saying that a left turn lane could be implemented. That's all it says.
Okay. Mr. Buck, you got any questions, sir?
Well, just to follow up, it says should be implemented, not could be implemented. I would like to see if Monty's here today to speak on what transpired and how some of these letters came about, and just give us a little bit of clarification on that.
Good afternoon, Commissioners. Monty Hankins, Elbert County Public Works Director. Yes, so Dale Gillian is overseeing most of the review for development and things of that nature. Dale did the first analysis of what transpired with the RV park and also the Kimley-Horn initial survey. He then met with me because there was a lot of back and forth with this, and I said, let's have Kimley review just to dot all the I's, cross all the T's, and make sure we're on pace. Consider the school, consider the hill coming down to the location, things of that nature. So we did that. It was as simple as that. And then they came back with what CJ just told you, with that new letter and with a possible recommendation for a left turn lane. I then did send out a letter saying that I recommended turn lanes associated with the RV park to ensure safety per the hill, per the school. The new traffic study, I've read it. Okay, I get it. There's a lot of safety associated with the area. The school is less than 3/4 of a mile away from the location. In the past, I wish I wasn't in charge, but had I been in charge, the landscape company would have turn lanes. The hay place up north of Running Brook would have turn lanes, and so on. The land that's probably going to sell just north of this location, per the new amendment 728 within the road standards, will be required to do turn lanes. Now that you guys have approved those new road standards, that's just a part of what's going to happen along that road per our criteria. Does it match up with CDOT's? No. Does it need to? No. So, I mean, that's where I'm at. I'm for the turn lanes. That was my letter. I still stand by that letter. Dale and I both are on the same page. and that's how that transpired.
All right, Commissioner Schroeder, any questions, sir?
Not for Mr. Hankins.
Commissioner Buck, any questions?
Yeah, Monty, you said you stand by that letter, you're for the turn lanes. Are you for a left turn lane and decel and acceleration lanes as well?
I'm for the turn lanes. I don't know if I necessarily am about having the XL decel lanes. I think, you know, the gentleman that was up here with the however many RVs they guesstimate might come in and out of there, I think the turn lanes would be sufficient. I don't think XL decel lanes are necessarily required or necessary, in my opinion. Nor do I am not sure if we have enough right-of-way all the way down through there for that.
Okay, thank you.
Thank you.
So before you leave, just one question. You just mentioned enough space to even put the right-of-ways and stuff through there. Do we have, you don't think we have enough to do that as far as?
To do turn lanes, yes, sir.
Okay. All right, thank you. That's all I have.
Thank you.
All right, thank you. All right, any other discussion on this?
I'd like to make some clarification.
Sure.
For the weekday condition, 90% of the traffic is coming from the south. Only 10% is coming from the north, which means you have nobody making a left turn in the morning or evening peaks. You have one vehicle making a left turn out in the evening and one vehicle making a right turn in the morning. That is it. There's no vehicles during the peak hour making any left turns into the site. So you're putting a turn lane in that's not going to get used. I mean, it'll get used when people come there during the day, but you design it for the peak condition. If you look at the peak condition, how would you justify putting a turn lane in with 0 vehicles making a left turn? I don't understand it, I guess.
All right, thank you. It's noted. Thank you, sir. Anything else? Cool. Yes, sir.
John Goodrill, representing the Goodrill family, that this has been a frustrating, to be on my words. Me and my wife, we looked at this, said, how can we keep this piece of land in my family's name? Because my mom and dad are in their late 80s, and unfortunately, the one fault my dad had was he was old school and thought he could work until he was 110. We can't, okay? But 55 years, we've had a company, Ponderosa Tree Company in this county. I went to every person I could talk to explaining why I'm doing this, including the Angels. And her husband said, we agree with you, we respect that, we understand why you're doing it. My family ain't selling a bunch of land around Elizabeth, and we're granted to give me 100 acres. It ain't gonna work that way. I'm the youngest of 8. And this is emotional, not because of RV park, because of my father. Because he busted his ass in this county to have a business and create land and own land. And we're doing everything we can do to support that land and keep that land in my family's name. So if I get up here, because I used to be a coach, and I got a lot of emotion in this, because I am my father's son. And I will not stand here telling me that I can't put a business on my own property when I've met every standard that Elbert County and EDZ has sent forth me. Retention pond. Don't even understand it, because I have a pond, but I'll build it. Fencing, we already have it there, but they're telling me I have to put up a 6-foot privacy fence around something that I will be looking at. I will do it. You guys don't like RV, I get it. I know that for a fact. I understand it. And I look at the other RV parks that were built, or storage, I mean, and I see what you guys are saying. So when I presented my plan to you guys, I built mine 800 feet off of County Road 13. I am not putting 6-foot trees in every 100 feet to say I'm softening it up. I am putting 31 20 to 25-foot spruce trees that are very valuable in my business because that's my business. But I respect the county enough because I've grown up here and I've lived here. I respect the county. I respect your vision of what you guys think the county should look like. I respect my neighbors to the south. And when I had that conversation with them, I said, I will put as many trees up that needs to be. And they said that to me. John Angel, we had this conversation. If we need to add a few more, can we do it? I said, you darn right I will. Because I respect them. And my word is my word. When I come up here, I give you my word. It's a handshake. I don't need a bunch of contracts. But I've done everything. I've spent north of $60,000 to get to this point. Just to build this. And it ain't like it's cheap. I'm pretty sure you have interest in mini storage, so you know it's not cheap. It's a lot of money to get to this next point. But I took the risk. And I don't think we're asking for more than, and we're even willing to work with you guys on what improvements we can do to help out. And as soon as we did that, I'm gonna be honest, it felt like to me, you guys went opinion shopping to find an answer that didn't add up to me being able to have this business on my property. I say that to you guys because I want to applaud you, first of all, for what you guys did against Excel, okay? I own land where the Excel power lines are going through. And I tell you this because you're right, Commissioner Buck. It does affect values. We subdivided 4 35-acre lots up our property to create the money to generate this RV storage and generate the money to buy my parents' property when the time comes. Like I said, I'm the youngest of 8. 6 brothers and sisters are left. And when the time comes, I either sell it to the highest commercial bidder and let them deal with it, or I create a business that will allow me to buy that property when the time's right. My sister, who has been a caretaker for my parents in their old age, she can stay there, or one of my 4 boys will have the opportunity to move into there. I have no intention of selling it, have no intentions of doing other than trying to create a business that will support that piece of property. You guys, I listened to every single meeting that you guys had with Excel. And they were the behemoth, giant commercial company trying to come in there and take away our property rights. And like I said, I applaud you because you guys did what you had to do for property rights of landowners in Elbert County. And to me, quite frankly, the shoe was on the other foot. I am now fighting the county that I have paid a lot of taxes for, paid a lot of money to get this all created, and I said, I don't want to go down this road if there's an issue. And we looked at traffic first, we looked at FEMA, we did everything we had to do. And we passed everything. Every single thing that you guys set in front of us. I'm going to quote you, sir. I'm going to do the best I can because I like what you said. You were raised that sometimes
Never the wrong time to do the right thing.
never the wrong time to do the right thing. Thank you. And I love the hell out of that saying. I think what we have presented to you guys and what we've done and what we've been willing to try to make this as safe as possible, which the first thing I can tell you, because I'm on that road every day, all day long, take the speed limit at the top of the hill and turn it down to 35. Because I have a son that's 15 who's going to be driving his car now. I had 4 boys that have been through this county. Slow it down. That's the first thing you can do, especially coming off that hill. If you think the hill is too much of a sight, it's not, but that's the first thing we can do. And I presented that to Monty when I spoke to him, and Monty said that's a great idea because of the land safe supply. Slow it down there first. I appreciate your time. I know it's a tough job. I've got to do everything I could do to keep this property in my family's name, and I am willing to do anything I have to do.
I appreciate all that, but I want to clarify something. It's not about us liking or disliking RV storage places. It's about the safety and these kids being that close of proximity to that area where that hill is. Now, we got differences of opinion, that's fine. But one of the things that was recommended was what you said, was about lowering the speed limit there too. That's one of the positive things that we could do. It's a simple thing to do. So that's something we can work with Road and Bridge on, see about getting that done. We're not trying to keep you from losing your or keep you to lose your property or prevent you from having an RV storage there. What we're trying to do is make sure that that area is safe going forward. That's it. That's it in a nutshell. And we're getting all these different opinions, and everybody's got a different opinion about it, and that's where we wound up. So we're all looking like, what do we do here? We want to do the right thing. I'm speaking for the board. We want to do the right thing.
Okay.
And we want to help you. As you said, you've been in what, second, third generation here.
Yep.
It's about the safety right there of these school kids. That's what it's about.
Like I said, I have school kids. I got grandkids.
Understood.
here,
I do too.
4 generations, so
Yeah,
I get it.
got it.
And we were willing to work with you guys.
And I appreciate that.
All right.
Thank you.
Thank you, guys.
All right, so we jumped ahead here a little bit. Is there any public comments here? We want to make any additional comments? Okay, seeing none, move us to an action item at this time, if you'd like. Is there a motion?
I'll make a comment and then a motion. I want to apologize to the applicants to go through this and keep having the goalposts moved as you go through a process. Is not fair. It doesn't put our county in a good light. The documentation is there. We may not like what the regulations say of what is allowed there, but we've made adjustments to that. But we can't go back and impose regulations on somebody that we passed recently on when they first started their project. I think that's patently unfair. Other than there's obviously a few differences of opinion. The letter we just received yesterday, it doesn't appear to me as though this gentleman is qualified to make an opinion on roadway design. And so to me, it does a lot of the things that Mr. Noble said resonates with me in regards to this letter. And it is, I'm embarrassed that we've got to this point where we're adversarial with our citizens trying to do something with their property. So I'll make a motion that we approve Running Creek Storage EDZ 2024-3548 with the 4 conditions of approval listed.
There's a motion. Is there a second?
I'd like to make some comment.
Sure. Go ahead. You have a comment?
And just wanted to clarify, no one's trying to deny anybody the right to a project or to do what they want on their particular business or on their land. I respect that. I respect small business owners. And I actually like some of the aspects of that project. I like the fact that it's set back off of the highway, County Road 13. I appreciate that, so it's not right up against the roadway there with a 6-foot cyclone fence like you see so many times through Elbert County now. I appreciate the fact that you're willing to put in a large buffer and truly buffer it. So you have a nice setback, you have a large buffer, more than what was required. And I just wanted to clarify that I think you're trying to say, and I sense your frustration, but I think you're trying to say that we're not honoring your property rights, but nothing's changed since the first day I heard this application. The first day I heard it, I haven't changed. The opinions of some of the engineers and some of the, people that we've talked to have changed, but my decision my thought process was always one of safety and the future of Elbert County. And sitting on this board, I think that's part of our responsibility is to think forward and plan for the future, not just one particular applicant. So I'm at kind of a crossroads there with this application. And I'll leave it at that.
All right, we've got a motion on the floor. Is there a second? All right, I've got a second to motion. At this point, I think further discussion. The reason I've got one other comment to say. We've had a lot of different opinions, as I've said before. Now, I disagree with Commissioner Schroeder. I'm not embarrassed by standing up for the county and for safety, especially for our kids. I'm not embarrassed about that at all. There was a lot of, maybe we'll say, miscommunications or failure to communicate with the building and permit department, CJ. So if you get in that situation again, I'd suggest you reach out to one of us. But that's where I'm at on it at this point. So we got a motion, we got a second. All in favor?
Aye.
Aye. Motion carries. I'm sorry, opposed?
Abstain.
Abstained. 2 in favor, 1 abstained. Do you have that for the record? All right. Thank you, sir. All right, thank you. You're approved. All right. Motion to close this Running Creek RV Storage EDZ 2024-3548. Is there a motion?
I move we close the public hearing on Running Creek RV Storage EDZ 2024-3548.
Is there a second?
Second.
All in favor, aye?
Aye.
Aye. All right, next item on the agenda is continued from June 2025. Sorry, I get this mic up here where you can hear me over there. This is on the Pine Ridge Metropolitan District Service Plan.
Yes, give me 1 second as I pull up the presentation, but I'm actually going to be turning it over to Graham Anderson with Anderson Analytics. He will be giving a presentation about the details of the Metro District, and then following the applicant team is present as well with the presentation.
Okay, thank you.
Kelsey, do you want to read the staff report first?
So before you today is the Pine Ridge, the new service plans for the Metropolitan District. The summary of the request is just for the creation of this new Metro District and associated plan. As you probably know, the Metro District is a quasi-municipal corporation. It provides the financing mechanisms for development projects. Other than that, that is all staff has for a summary.
As stated before, my name is Graham Anderson. I'm with Anderson Analytics. I've been engaged here and with prior service plan submittals to review the number side, and we work with law firm Butler Snow as well. That's engaged by the county to review the legal side, and of course we also work with the staff to review these. And I'm also engaged to provide the presentation of the key points of the proposal. What I'll present today is, first of all, an overview of the key service plan authorizations proposed for the district. Second of all, some context and comparison of the proposed district mill levy, and then finally a summary of the materials submitted regarding the financial plan and the district's proposed debt. Vicinity map and build-out summary. This vicinity map is excerpted from Exhibit A in the service plan, and you can see in gray there the proposed inclusion area, the proposed boundaries of the district. Just west of the town of Elizabeth, it borders to the northwest of the Wild Point subdivision. Over on the right, the build-out summary, which is shown in the numerical plan, which is Exhibit E. I should note that the numerical plan is a hypothetical example of how the financial plan may be executed, but that build-out summary shown there is 186 single-family homes with an average market value of $1.05 million, a delivery period from 2027 to 2030. The inclusion area proposed is approximately 420 acres. The service plan states that the population of the district at build-out is estimated to be approximately 650 people. And finally, importantly, approval of the service plan by the county does not imply approval of the development of a specific area within the district, nor does it imply approval of the number of residential units identified in the service plan or any of its exhibits, which approvals shall be as set forth in an approved development plan, which is a separate item as to what we're looking at today. Overview of probably the key points of the proposed service plan. Proposed district would be authorized to utilize general obligation bond financing to fund eligible public improvements. The total debt limit of the district is proposed to be $70 million. That's general obligation debt, and general obligation means bonds or debt that are backed and paid by a property tax of the district. The proposed maximum debt levy of the district is 65 mils in what we might call base year rates of 7.15% residential and 29% non-residential. That maximum debt levy is subject to what's called the mill levy adjustment. That essentially means that if there are changes in the method of calculating assessed value, like changes in assessment rate or market value exemptions, then that maximum debt levy may be adjusted such that the revenues are neither enhanced nor diminished as compared to that base 65 at 7.15 and 29%. And at the bottom is just kind of a simple example of how that works. So say all of the property in the district was residential, and before adjusting for the tax year 24 market value exemptions, you would take 65 mils and multiply that by 7.15 and divide by 6.7, and that would be about 69.4 mils. The proposed debt levy is authorized, what's often called limited convertible to unlimited, but specifically that means it may be adjusted higher than the maximum debt levy by such amount as is necessary to pay the debt service on the debt, only if or once the outstanding bond total is less than or equal to 50% of the district's total assessed value. Stated another way, that could only trigger if the district's total assessed value is at least double the outstanding debt of the district. There is no proposed levy cap for the district's operations and maintenance mill levy. The numerical plan did not include projections of those operations and maintenance revenues, and so in response to a question about that, the applicant wrote that 10 to 15 mils will likely be sufficient at build-out to fund the district's annual admin and compliance expenses. And the applicant also wrote that because it is not yet known what improvements the county or other entity may accept for ownership and maintenance, flexibility is needed for that operations and maintenance mill levy. And finally, the service plan anticipates that the developer would advance funds to the district to pay operating costs until such time as the district has sufficient revenue from its operations and maintenance mill levy. Fees. The district may impose and collect fees for services, programs, or facilities furnished by the district, and the district may from time to time increase or decrease the fees. The district may use the revenue from fees for the payment of operation and maintenance costs and for the payment of any debt. The numerical plan, which again is a hypothetical example of how the financial plan may be executed, it shows a one-time tap and facility fee of $35,000 per home built, paid at the time of construction by developer or builder, going to debt service on the bonds shown in the numerical plan. In response to a question about any other anticipated district fees, the applicant wrote that the district is anticipated to be the water and sanitation provider if other entities won't accept those improvements. Thus, the district may need to impose service fees or other facility fees to support the expenses of that enterprise if needed. Also, in response to a question, the district or the applicant stated that the district will not be providing covenant enforcement services. An HOA will be established. That's a totally separate entity from the Metro District. And we always ask applicants this, but the applicant wrote they do not know what fees or assessments a future HOA might impose. Exhibit D is the general description and cost estimate of public improvements that was prepared in January of 2025. This table summarizes broad category summaries of those cost estimates. There is greater line detail in that Exhibit D, but roads about 12 million, domestic water about 11.2 million, sanitary sewer 12.6, storm drain 3, parks and open space 1.5, and then with 10% contingency, that totals about 44.4 million in total public improvement cost estimate. And again, for context, the proposed service plan debt authorization amount is 70 million, and as I'll summarize just a bit, the numerical plan shows cumulative net bond proceeds for eligible costs of about 31.3 million. Switching gears to the context and comparison in terms of the proposed district mill levy. Just starting out with the overlapping property taxing entities. Of course, it's in the county and the county library district. The entirety of the proposed district is in Elizabeth School District, Elizabeth Park and Recreation District, and Elizabeth Fire Protection District. Certainly with uncapped O&M levy and all of that, there is some variability in terms of what the Metro District's mill levy could be. And so this is just an illustrative example, but taking from that first slide, adjusting the max bond levy from 65 to that 6.7 rate. And then also showing here, just as an example, per the applicant's answer, operations and maintenance levy there in the range of 10 to 15 mils. And so bottom line, total mill levy load, approximately in the range about 156, 161 mils there in that example. This table actually might be a better illustrative example here. This is an example residential property tax bill based on the average home shown in the numerical plan. At the upper left there, you can see an average market value of 1.05 million. And this is shown in tax year 24 payable 25 assessment rates and that market value exemption as well per that property tax policy and the payable 25 certified levies of the overlapping entities. Total existing entities overlapping, 76.57 mils. That works out to be about $5,100 there in property tax payment. The proposed, this example, bond levy for the district, I actually adjusted that there for the market value exemptions based off of the entire district. So you can see that's in the low 70s there. And just splitting the difference between 10 and 15 mils there as an example for the operations and maintenance. So about 85.7 mils there in that example for the total Metro District mill levy load, and that's about $5,700. We always provide this context here as well. These are the tax year 24 payable 25 total mill levies in the other residential Metro districts in Elbert County that have a debt levy. An asterisk there, you can see E86 Metro District and Toro Metro District are in the town of Elizabeth, so those were town approvals, and the remainder are in unincorporated Elbert County. The top line there on each of those is the total mill levy load paid by property owners in those districts. Beneath that is the total Metro District mill levy, debt, as well as operations and maintenance for all of those, and then beneath that are the existing entities there. And you can see the range there of the other residential metro districts in the county. And just from that previous slide, again, that was about 162 mills. Switching gears here to the financial plan and the proposed indebtedness. As you'll probably see in the staff summary there are 8 criteria in the county's special district policy that are from the statute. Really the matters and what I'll present on the following slides primarily relate to this subsection D here, which is evidence satisfactory to the board of each of the following is presented. The area to be included in the proposed special district has or will have the financial ability to discharge the proposed indebtedness on a reasonable basis. Again, the proposed service plan authorizes the district to issue up to $70 million in general obligation debt. I'm going to read a couple of sections from the service plan here, and this resulted from some questions and comments that we submitted to the applicant after reviewing the numerical plan. Applicant's counsel highlighted probably 2 important things that I'm going to essentially read here from the service plan. First of all, section 6 of the proposed service plan, so it's about 3 pages and it's written in words, is the financial plan, as the term financial plan is used in the statute. So as said in section 2, financial plan means financial plan described in this section 6, which describes 1, how the public improvements are expected to be financed, 2, how the debt is expected to be incurred, the estimated operating revenue from property taxes in the first budget year, and a hypothetical example of how the financial plan may be executed is set forth in the numerical plan. However, the principal amount of each issuance, the number of issuances, the actual terms of issuance and years of issuance will be as determined by the board of the district. And such changes in terms and years shall not be a change of the financial plan and shall not be a material modification of the service plan. And the numerical plan, which is shown in Exhibit E, its numbers, it's essentially a bond sizing model prepared by Piper Sandler Special District Group. They're an investment bank and probably the largest municipal bond dealer in Colorado, if not the Mountain West. But the numerical plan is a presentation of how the financial plan might be executed. The financial plan incorporates all the provisions of this Part 6 of the service plan, including the numerical plan, which is a numerical example of an application of the financial plan described herein. The second thing that I'm going to read here that the applicant's counsel highlighted for us was this Part A of Section 6, which is the financial plan, which states in relation to that subsection D criteria before, quote, the financial plan demonstrates that the district will have the financial ability to discharge all bonds to be issued as part of the financial plan on a reasonable basis, since the district, 1, will be issuing debt on a phased basis to support new development, 2, will not pledge to impose property taxes for repayment of the debt in excess of the maximum district debt mill levy, 3, will issue debt that shall not exceed the total debt limit, and 4, will secure the certification of an external financial advisor certification as to the market reasonableness of the terms of any privately placed debt at the time of placement. Switching gears to the numerical plan, which I'll provide a summary of. Also from that section 6A, the numerical plan is a consolidated presentation of the district's revenues, includes the district's estimated property tax, revenue available from specific ownership, and fees and other amounts available for payment of debt service on the bonds, and property taxes available for operations and maintenance expenses. The numerical plan projects the issuance of bonds to fund the public improvements and anticipated debt repayment based on the development assumptions and absorptions of the property within the remaining phases of the project. At the bottom here is probably the one-sentence nutshell of the numerical plan. The numerical plan shows 2 bond issuances over an effective 40-year bonding term. Those bonds are sized at that proposed max debt levy. I'll summarize those in the following slides. But the total par amount of those two bond issuances shown is $54.62 million, accounting for the portion of that second series of bonds used to refund, which don't count towards the debt limit. The bond shown towards the debt limit totals 37.79, and again, the total debt limit is $70 million. I know this is an intimidating table, but this is usually one of the first things I look for in any kind of bond offering statements. A sources and uses table. Essentially what it summarizes are the sources of funds that come from the bond issuance and other available funds. And at the bottom are the uses of those bond proceeds and other available funds. Just starting vertically, you can see under Series 2026, the numerical plan shows a first bond issuance on December 1st of 2026 with a 30-year term. The par amount of those bonds there, highlighted in red, $23.185 million. That counts towards the proposed total debt limit. And then beneath that, under uses, of course, there are costs of issuance associated with that, a debt service reserve fund. That bond series shows 12 months of capitalized interest, and so that yields, in gray, net proceeds for eligible public improvement costs of about $19.4 million. And then the numerical plan, 10 years later, it shows a second series of bonds, also a 30-year bond issuance. So 10 years later, that becomes effectively a 40-year bonding term. A general obligation refunding bond series, which is used in part to refund the balance of that original bond series at that lower interest rate. You can see that under uses, the $20.185 million. That goes to refund the Series 2026. I should note that in Section 63, the district shall not issue debt which is in excess of the total debt limit, provided that the foregoing shall not include the principal amount of debt which has been refunded, so that 20.185 doesn't count towards the debt limit. That's pretty typical because it's usually in everybody's best interest to be able to refund debt at a lower interest rate. The amounts there that do count towards the debt limit are highlighted in red. So net proceeds for eligible costs there of about $11.9 million. And then that series also is shown with the debt service reserve fund and, of course, costs of issuance. I'll provide hopefully a brief overview of some of the key parameters in that numerical plan. Really, there are two sides of the driving variables and assumptions in any kind of bond sizing. One side is the projection of revenues available for debt service. That's driven by the assumed development, the property values, the inflation in those property values, and then finally the fee and the mill levy rates. And then the other side there are the bond financing assumptions, which is really primarily the interest rate and the debt service coverage ratio assumptions, but as well, of course, reserve fund requirements, structured timing, et cetera. This is a summary of the build-out schedule shown in the numerical plan. Again, 186 homes, a delivery period from 2027 to 2030. The numerical plan assumes an average market value per home and essentially current values of $1.05 million. It models 2% annual inflation in those market values before delivery, and then after delivery with every biennial reassessment, it models 6% inflation in market value after delivery. This is a graph that we've always included for context there in terms of the rate of home value appreciation. This shows the annual change in the Elbert County All Transactions House Price Index from the U.S. Federal Housing Finance Agency. So 6% biennial, of course, is about 3% annual. You can see that in the upper left. And then those numbers beneath that, I've shown the average annual appreciation through January 1st of 2024, 10-year, 20-year, 30-year, and 40-year historical. You can see 10-year average annual is 7.15%. Compare that to about 3%, 20-year 4.2%, 30-year 5%, and 40-year 4.4% annual average appreciation. This is kind of a recap again of the sources and uses table there. First bond series, the series 2026, it's a 30-year bond issuance. It assumes a 5% interest rate or coupon rate on those bonds. Timing-wise, those are shown issued just around the commencements of construction on the project, so those are unrated bonds. Those bonds are sized at only 1.0 times coverage. They're sized from the maximum debt levy, and again, a bond par amount of $23.185 million. And then the Series 2036 General Obligation Refunding and Improvement Bonds, also a 30-year bond issuance. It assumes a 4% coupon rate. The project is already in place, so those are assumed investment-grade bonds. Also sized at only 1.0 times coverage, also max debt levy, and that goes in part to refund the Series 2026 for an effective 40-year bond term combined. And the total bond par amount from that is $31.435 million and $16.83 million, accounting for the reserve fund from the Series 2026, and all of that goes to refund that Series 2026, and that does not count towards the debt limit. We always provide an assessment of those bond financing assumptions in the numerical plan. The mix of bond coupon rate and debt service coverage ratio assumptions, 5% at 1.0 times coverage for unrated 30-year bonds prior to delivery, and then 4% at 1.0 times also for 30-year rated refunding improvement bonds. We would generally say those are representative of historic best case bond market conditions. 6% biennial residential market value appreciation is assumed. The typical bond underwriting parameters in Colorado's community market is typically ranges from 2% to 6%. Really around 2019 to 2020, there was more emergence of 6% underwriting there. There's been a bit more pullback from that, probably over the past 12 months, a lot more 2% and 4%. Also, the max debt levy, again, is modeled over the total 40-year period, and so overall, the numerical plan is probably generally representative of max capacity bond sizing parameters, assuming that build out of 186 homes and a starting home market value of $1.05 million from the debt levies, property tax revenues over a combined 40-year bonding period. And then again, numerical plan shows $37.79 million in debt issued toward the total debt limit over the 40-year bonding period, which from those two yields about $31.3 million in net proceeds available for eligible public improvement costs. And finally, a recap of probably the biggest points in the service plan. The proposed service plan debt authorization amount, the total debt limit is $70 million in general obligation. The proposed debt levy cap is 65 mils at those 7.15 and 29% baseline. The proposed operations and maintenance levy is uncapped. The estimated total cost of public improvements in Exhibit D is about $44.4 million, and the proposed district inclusion area is approximately 420 acres, and the numerical plan illustrates an example build-out of 186 single-family homes at an average market value of $1.05 million. This is really all that I have for you. I'm not going to walk you through the bond repayment models, but there is more of a condensed summary as compared to the numerical plan and the service plan there if you want to see a two-page summary of those bond issuances. I appreciate your attention, honorable commissioners, appreciate your time, and I think it's time to pass it to the applicant.
Thank you. All right, anybody else comment on that? Kelsey, you got anything?
So we actually have another presentation for you all.
Okay, thank you. Go ahead, ma'am. There you go.
Try that again.
For the record, could you state your name again, please? Thank
I
you.
apologize. Usually red means stop and green means go, and I completely missed that. My name is Suzanne Mincer. I'm an attorney at the law firm of McGeady, Becker, Cortez Williams in Denver, Colorado. We represent the petitioner, MF Investment Partners. I'm here today on behalf of petitioner, and there are two of the principals with the petitioner as well, one of whom I believe will be addressing the commissioners today. My last name is a little bit tricky, so if you're not too offended by being informal, please feel free to call me Suzanne. What I thought I would do for you today is just give the commissioners some historical context about what a metropolitan district is, why they're used, delve into what a service plan is, and then specifically address this service plan, although Mr. Anderson did a lot of the heavy lifting for me, so thank you, Graham. And just to clarify one thing, today we're asking for the commissioner's approval of the service plan only. There's a separate court proceeding to actually create the metropolitan district. And what I mean by that is, if the board were so inclined to approve us today, there's a separate process where we have to file a petition with the district court. The district court orders the election, and after all that happens is when the district is actually created. So just very generally, why do folks use metropolitan districts? In short, they're a financing tool. They're a financing tool to be able to install public infrastructure needed to serve new development. And that's because oftentimes municipalities and counties don't have the revenue available to do that. One thing that gets missed, I think, a lot is that metropolitan districts are governmental entities. And so that last point there is, once formed, we are subject to all the same local government laws that you folks are subject to. So we are subject to the state audit laws. We are subject to open meetings laws. We are subject to open records requests. We are subject to the budget laws and audit laws. So just some historical context here. I think that there's been a concept or an impression that metro districts are new. They are not new. They have been used in some form since 1861, before the state was even created. And it feeds into this kind of Colorado, I guess, culture that development should pay its own way. In 1981 is when the Special District Act was codified, and so now it's part of Title 32. This slide is just to orient the board. There were several updates have been made since it was codified in 1981. Just for example, in 1991, it was changed where we have to post notice of the agenda within a certain time frame. In 2009, that's when we became subject to audit laws. In 2013, there are special notices that the district has to issue when we're about ready to issue debt to the people who are subject to that debt mill levy. In 2019, with COVID, the state legislature let us meet virtually. In 2023, and actually now in 2024 and 25, I didn't update the slide, there have been a lot of updates with respect to transparency for the public. The last one in 2024, I put in light gray text because, as Mr. Anderson said, this particular metropolitan district will not be doing covenant enforcement, but metropolitan districts do have that authority. Basically, I already said this, but are these useful moving into the future? We believe so. It's a way to finance the public improvements necessary to finance and install the public improvements that go into new development. So just to explain what a service plan is, A service plan is the document that defines the parameters in which the metropolitan district has to operate. I like to think of it as analogous to a municipal charter or a state constitution. So like those documents, it has to be flexible enough so that we're not coming back here every year to ask you folks for an amendment, but it also has to be restrictive enough that we're not allowed to go beyond the bounds of what is in that service plan. And so a service plan tells us what we can do, what type of infrastructure we can install, and what types of things we cannot do, or our limitations. And so we're not allowed to impose a mill levy over the maximum mill levy. We're not allowed to issue debt that's in excess of the debt service plan unless we come back to you folks and get permission. Oops. So Graham covered a lot of this. Basically, it's about approximately 420 acres. There'll be about 185 1 acre to 1.5 acre lots, single-family lots. It's anticipated that this district will be the water and sewer provider for this project and potentially future projects, excuse me. Let's see, and I already said we're subject to all the local government laws and that we're not going to perform covenant enforcement services. We're asking for a maximum debt mill levy of 65 mills, and to give you the context of where that comes from, there was about a 13-year time period where the residential assessment rate between 2003 and 2016 was 7.96%. So today, as Graham said, it's dropped. I don't know what it is right now. Last year it was 6.8% after a $50,000 deduction on actual value. But anyway, 50 mills in 2000 adjust to about 68 mills today, which is where that 65 mills is coming from. And we're respectfully asking for that just to make sure that this project is competitive with others in the county. The interest rate is capped. The reason we're asking for the 70 million in the total debt limit is if you take that combined par amount of around 57 to 58 million, in 5 years at an average inflation rate of 4.7%, we're already at $70 million. And I set forth the historical for the past couple of years inflation rates. And so we know that that sounds like a lot of money, but that's where the ask is coming from, again, is to give us that flexibility in case things change, construction costs go up, that type of thing. Graham also mentioned this, but another limitation that we have is that we have to get a certificate from an independent financial advisor if we're going to be issuing privately placed debt, which is usually debt held by the developer. And that was very simple. We believe we've met the statutory requirements. It's on the very last page of the service plan, the 8 things that the board has to find. Last, for the record, I'll just mention that the county has specific mailing, posting requirements, which we have met. Title 32 has another set. We believe we've also met those, for the record. So I'm not sure if the commissioners have questions, or if Jim, if you want to wait till they have questions.
Thank you.
Thank you.
I've only got 1 page notes, so we're good. It's Jim Marshall, 4091 East Chestnut Court, Greenwood Village. First of all, Suzanne stated 185, Graham stated 186. It is 186 lots. That's what we're approved for, and the zoning is approved. Graham did a very thorough job. He hit all the hot buttons. He took away a lot of the stuff that I probably would have said. Couple of things that I just wanted to clarify is that when Graham went through his summary of how we go about issuing bonds and interest rates and everything, he said that we're kind of, we're in the ballpark. I'm paraphrasing. We're in the ballpark with interest rates, but maybe we're on the more aggressive side of center with our assumptions. Rates change dramatically over time. We're always at the mercy of the marketplace when we issue bonds. Today, we have no idea what the interest rates are going to be. I've refunded bonds as low as 1.95% over the last 10 or 15 years, and I've refunded bonds as high as 4%. So there's a broad range of refunding, but refundings are, and Graham mentioned this, refundings are rated, and we usually get a BBB plus rating. We work with Moody's and different rating agencies to get our ratings, and we do have a independent third-party financial advisor that signs off and opines to our interest rates before we close. Actually, that happens when we price, and so there's all kinds of checks and balances in here. And we're trying to get the best rates we can too. I'm not interested in issuing bonds at 7 and 8%. I think the highest rate I've had that I can remember on an initial non-rated deal is probably in the 6.5 range. I guess there was some bonds back in 20 years ago that were closer to 8%. But rates have historically come down. Obviously, we went ridiculously low about 4 years ago. Don't expect to see those rates anytime soon again, but again, we're always motivated to get the best deals we can. The other thing, there's a lot of variables in here, and when we looked at Pine Ridge, and because I've been involved in the county since roughly 1999, and I do talk to everybody out here pretty regularly. We kind of think we know where things are going relative to maintenance. Historically, the county has agreed to maintain certain roads in certain subdivisions. Spring Valley is a good example, and that appears to be changing. So we've made the assumption, right or wrong at this point, that we're going to probably have to maintain most of our roads in perpetuity, which means that our district will refund bonds down the road, because eventually, 30, 40 years down the road, if the county's not maintaining the roads, the district's going to have to rebuild those roads. And we need to make sure we've got the mill levy and the financial capacity to do that. And it's a little, and I can relate to where Monty's coming from on a lot of things. As a public works director, we don't know. We don't know what it's going to cost 20 years from now or 30 years from now. So we need the flexibility to be able to do what we need to do at whatever that price might be. The nice thing is property values, as construction costs inflate, typically house prices inflate also. So usually that inflation kind of matches each other, and again, we should have the money to be able to do what we need to do long term. I really didn't have a whole lot else. I did want to mention, he showed E86 and Retoro, those happen to be my communities, and those are in the town of Elizabeth. The town has accepted all of the roads, all of the water, and all of the sewer for maintenance purposes. So those districts, those mill levies, and the refundings in those districts are going to be less because we don't have to deal with the maintenance issues. As you guys know, Elbert County is a different animal, and it works differently out here. So that's it. Happy to answer any questions. What do you got?
Mr. Schroeder, just real quick, if I understood Mr. Anderson's slide, issue date of December 1st of 26, a year from now?
That's probably not going to be realistic. We prepared this several months ago. The preliminary plat is in the door right now. It's going through the referral process. We have not got the comments back yet. I think they're due almost any day. We have to put a number in there, and when we put it in there 6 or 8 months ago or 10 months ago, that seemed realistic. Today, maybe it'll shift a little bit. But again, the service plan is all about meeting the statutory requirements. It's not meant to say this is exactly what our bond issuance looks like or when it's going to be issued. It's giving you guys an idea of what it might look like and what you can expect.
And I'm not sure if this question is for you or a comment to staff or where this, but the IGA example that we have in our packet, the contact information for Elbert County County Attorney and CDS Director are incorrect. So that was left over from before and hasn't been updated, but it probably needs to be changed.
Yes, we can make those changes before recording.
That's fine. One other thing I was going to mention is you saw the $70 million number, you saw the $54 million number estimated. We have multiple sources of funding infrastructure costs. And Suzanne said it, this is a tool. This is one tool we have to issue debt that gets paid back over time at lower interest rates and tax-exempt interest rates. So the other sources, though, are developer contributions and home builders. We build the public infrastructure through the district that the local jurisdiction does not build. That's probably a really good way to say it.
Any other questions, sir? All right, Commissioner Buck.
Yeah, I got a couple quick, simple questions. One of the things you talked about, and I'm just curious for my own benefit, 650, what was it? People out of 186 homes gives you a factor of about 3.5. So I've seen some of these larger developments come in and they're using a 2.6 or a 2.7 factor. How did you get the 3.5 factor?
Well, 2.5 means the average family has half a kid. And
well, this one's 3.5, so
yeah,
you got 3.5 on this one.
I understand, but that's average. So these are bigger homes. We are projecting, roughly $1 million homes here. They'll probably start in the really high eights and go up into the 1.2, 1.3 million. But yeah, I think you'll see larger families in most of these homes. And the number of homeowners really doesn't have any bearing on anything relative to the finance plan or our ability to.
None at all. Yeah. And I admit that. I just wanted to see, and I thought, it ran through my head, well, they're larger homes, you may have more people in the homes, that kind of thing. I was just wondering where you got that number in relation to, let's say, one of the other developments that had been recently approved. They were using a 2.7 or 2.6.
Yeah, and
I was just curious.
Yeah, and Mike, it's, we don't know how the demographics are going to shake out, but I think generally in Elbert County we got a mixed bag. I mean, like Spring Valley is a great example. We've got empty nesters, we've got young families, we've got seniors, retired seniors that, we've got a real mixed bag. I can think of families that have 6 people in the house, and then there's other people that have 2. So you do your best, and you just come up with a number. Sure. It's
like you said, it's not relevant to what we're talking about.
Unfortunately, our business, and especially the financing, and when it comes to infrastructure costs, you look at the variables. Construction costs continue to increase. Interest rates are all over the map. They're up and down over time. AVs vacillate. They generally go up, but we actually had a period where they went down slightly back in 2008, 9, 10, and 11. So there's a lot of intent and variables that we don't have control over. We do our best to try to model them, and we deal with them as we have to.
So another question is Susan, correct?
Suzanne.
Suzanne?
Yeah.
Okay, sorry. Suzanne, you mentioned that there was 8 criteria that you look at, and you're with McGeady, Betcher, Cortez, and Williams, correct? So April 8th, in your conclusion, there's 9 criteria. And the 9th one, of course, is the one I have a question about, and that is in relation to the creation of the district is in the best interest of the area proposed to be served. What I have a question about is there's no cap on the operation and maintenance levy. I want to talk to that. Well, let me finish real quick. There's no HOA fee identified or capped, and then the fees that may be imposed and or raised or decreased at any time does not have any restrictions or any cap. So I'm trying to get to the point of saying, hey, this makes sense. This is in the best interest of the area that it's proposed, but I'm looking at it going, how do I know that if I have no idea what that HOA fee is going to be? I have no idea what those operation and maintenance levy fees are going to be. And then in your example on slide number 8, you said 65 mils was going to be a cap, and you could probably easily explain this, but then in your example, you jumped right to 73, and you used the 12.5, kind of an estimate between 10 and 15, which should be sufficient. So we got all these, numbers, and it's very analytical, and then we got all these generalities, and I'm having problems with the generalities and the assumptions and the estimates.
I do want to respond to it, but I'll let Suzanne.
First of all, I apologize, you're correct in my handwritten notes. So the way the statute is written in section 32.1, 2032, it's written in the negative. So it says the board shall not approve unless these four things are
I saw that. I thought that was interesting.
And then in section, or subsection 203, 2.5, it says you may disapprove if these other five things are not.
I got it right here.
So you're right, it's 9, and the reason is in my handwritten notes, number 8 with the long-range water quality plan, I didn't have that in my handwritten notes, so it's 9 things and not 8, I apologize.
Okay.
And then, do you want to talk about the O&M fee? So the 65 mils is the debt service limit. You're right, not the operation and maintenance mill levy limit, and the reason we're respectfully requesting an unlimited operation and maintenance mill levy is just for the reasons Jim said, is if this district is required to operate and maintain any type of infrastructure, we may need the flexibility if the folks who are in charge of the board at the time need additional O&M mills to fund repairs or maintenance for public infrastructure.
Yep, and I understand that, but my position is to make sure it's in the best interest of the area proposed to be served, and a cap, say, oh, we got some estimates, we think it's going to be between here, not to exceed might have been a good word to see in this document at some point.
Yeah, I think the problem, Mike, is that we are going to be maintaining a fair bit of our roads out here. Based on my experience at Spring Valley and my interactions with Monty and staff, is we will be maintaining the bulk of our roads, even if they kept the current policy. My suspicion is that might change as we go through the reg update and the comp plan update. But we need the flexibility to match the mill levies with the costs that we incur. What I can tell you historically, and I've got numerous districts, I can't think of a district right now where the O&M has gone much over 12 ever. And I think Spring Valley is still around 10 or 11. These are based on experience. It's based on actual O&M costs, but we need the flexibility to be able. If we get hit with we had that a couple of years ago, we had that really bad storm in the spring. If we had a bridge wiped out or something like that, we'd need to be able to react and do something about it.
So as far as a fee is concerned, so you may be able to do special assessments, annual special assessment, or some type of a bridge goes out. You might say, hey, we're going to hit every one of these homes with a $5,000 special assessment.
We really can't do that. So
Well,
that's not
that's what I was just asking.
that's not in the cards. We can't do that. And as far as I want to address the HOA real quick too. The reason we don't have a fee in there yet is we don't know what the amenities are going to look like. We don't know what the landscaping maintenance costs are going to be yet. We don't know what the road maintenance, there is a little bit of road maintenance early on, snow removal, stuff like that. Longer term, chip seal, crack repairs, that kind of pothole repairs. So the HOA dues, we're just know this, we're motivated to keep that number as low as we can because it's a marketing issue. People certainly, when they buy a home, are looking at that HOA fee, and they're also looking at their overlapping mill levies. So we're very sensitive to that. Back to the O&M part, we don't want to see the O&M be any bigger than it has to be, but we do need some flexibility there.
Okay, so yeah, I can understand your perspective with costs. Hard to, project.
I feel like especially over the last few years with COVID, and we had the ridiculously low interest rates, and then we had a run up in inflation, and construction costs over the last 3 or 4 years have gone up almost 50% on a lot of the stuff that we do. I'm just blown away by some of the numbers I'm seeing right now. They are starting to relax.
So real quick on that slide you guys did, I think it's slide 8 where you did the 73.199 mils. I probably just didn't understand what you were saying, but isn't 65% the cap? Or 65 mils, I'm sorry.
65 mils is the cap, but
Then in the example, then you use 73.
That was from Graham's presentation, I think, so I think he's
Might have been, yeah.
adding the debt of 65 plus 12 going in.
no, that doesn't add up either. For Gallagher? Yeah, Graham didn't call it a Gallagher adjustment, but that's what it's called. When the values drop and the percent drops from 6.8 down to something lower, we have to raise the mill levies to be revenue neutral. So if I collect, let's just say we get $2,000 off of your house, Mike, when the valuation is at 6.8% of actual value. That's how you get to the AV. When the state lowers that calculation back from 6.8% down to 6%, if we can't adjust our mill levy, we're losing money. All of a sudden, that $2,000 might go to $1,800 or $1,700. But all we're doing is adjusting that mill levy so that we maintain level at that $2,000 number that we had when it was 6.8%. And that's important to us and to our bondholders, because we've underwritten those bonds based on that revenue that we're going to get on 6.8%. But when those values percentages drop, we need to be able to stay revenue neutral. So you, as the homeowner, you're still only paying $2,000. Your mill levy went up, but because the percent of the actual value went down, you're paying the same amount of money in tax.
Interesting. So,
Yeah, that's what I thought too.
well, the reason I ask is because the 65 was a cap, and then right away on the example, you're already at 73.
But the other thing, and I think Suzanne mentioned this from, was it 2000? Back in 2000, 50 mills in 2000. I think if I remember, the mill levy, the percent back then was 10 and change, something like that. Yeah, 9.74 or something like that. And it used to be over 10. But in 2000, 50 mills in 2000, that gets us $2,000. Today, to get that 2,000, we need 65 mills. And that's why that mill levy will continue to ratchet up as long as the percent that we calculate AV versus actual value, if that percent continues to drop, the mill levy has to go up to keep us revenue neutral. And I know it can be.
So it sounds like 65 is not a cap, but I may be not.
Well, it's adjusted. It's adjusted based on the actual percentage of actual value to get to AV, so that we're revenue neutral. We're not getting any more money. The taxpayer is not paying any more money. It's all revenue neutral, because every time the state lowers those percentages, and they haven't gone up, they keep going down, we need to be able to stay revenue neutral.
I got it.
And if I may, that's not unusual. Other districts do the same thing for mill levy overrides. Elizabeth School, Elizabeth Fire, it works the same way, so that the revenue is neutral. So it's not
right.
It's not an unusual situation.
Yeah, and that's a good point, Dallas. The special districts, as Suzanne said, have been around a long time. And it's fire districts, it's library districts, it's every kind of district you can think of. And we all have the same issues. When the percentages drop, we got to maintain some level of neutrality on our revenues.
Explains it to me. I was just curious of why we started with that number versus the 65 in the example and in the table.
Yeah.
So it makes sense now that you've explained it, and
Yeah.
I think we're okay with it. I'm still not a fan of no caps on any of these, but I understand that.
It's standard in the industry. It's statewide, and again, from a developer standpoint and working with the homeowners, the other thing that didn't come up here, but as we have vacancies on our boards, which does happen, we are required actually by law to advertise those vacancies to our homeowners, and it's not unusual for us to get homeowners on the board with us. We actually kind of like it when we do, and right now at Spring Valley, I have homeowners on almost every board. It's nice to know what the homeowners are thinking. It's nice to have them involved in the process and the decision making, and they can tell their neighbors what's going on.
That's all I had.
All right, thank you. The only question I had was about the date, and you clarified that for
The what?
about the date, but you clarified that with Commissioner Schroeder.
Yeah, as far as the December of 2026 on bond issuance, that's just, honestly, it's nothing more than a best guess right now.
Right.
And the nice thing is, whether we issue bonds on November 1st or December 1st of 2027, nobody's paying any taxes till we issue bonds. You know, they'll be paying the mill levy, I guess. We'll be collecting mill levy on no value. But we generally issue our bonds, and I'm a little bit different than maybe some developers. I like to not issue my bonds until we have the first homeowners actually moving into the district. So I try not to issue my bonds too prematurely. A lot of developers will actually accelerate their bonds, issue them earlier. What that does to their proceeds is they have to park more money in interest rate reserves and surplus reserves. I like to try to keep those numbers down to a minimum so that I can maximize the dollars that I can put into infrastructure. So I tend to wait until we actually have homeowners before we get that first debt, or very close to the point where we have our first homeowners.
Got it. Thank you, sir. Appreciate it. At this point, we'll ask, is there any public comments, public input? Give us your name, sir, and address.
Brad Ide, 1110. Trail, Elizabeth. Some of this may have been discussed earlier because this was prepared before the presentation. But anyways, good afternoon. I have several comments regarding the Pine Ridge Metro District Service Plan. I have two general observations. The service plan does not address if the streets in Pine Ridge will be built by the Metro District and then conveyed to Elbert County to be maintained, or is the expectation by the Metro District and the county that the streets are to be maintained by the Metro District? What is the expected mill levy for the general fund if it is required for the present operation and maintenance of the streets? And more importantly, what mill levy will be required to cover the cost of major repairs in 20 years when the bond debt still has 20 years of principal and interest payments left? Will a reserve account be established to fund major road repairs in the future? My personal opinion regarding the repair and maintenance of roads in metro districts is that the policy should be as it was in the past. The Metro District builds the roads and then conveys them to the county after a 2-year warranty period. If the Metro District maintains the roads, the county is essentially forcing the Metro District to accept an agreement where the residents have a private road that is open to public use. It seems unfair to the residents that they maintain the roads in their Metro District while also being taxed by the county's Road and Bridge Department and contributing to the cost of maintaining roads in the rest of the county. As noted in the BOCC meeting on June 25th, when I discussed the repair of the potholes at the Murphy gas station, Metro districts may not respond as quickly as necessary to fix roads maintained by them. I have often heard that the county has insufficient funds to maintain the new roads in the ever-expanding subdivisions of Elbert County. I suggested the county review the 9.5 mil levy tax for the Road and Bridge Department, which has not been increased since at least 2014. I would like to see a provision in the service plan, and I'm sure if it really is a service plan issue or not, that mandates the Metro District residents be on the Metro District board as homes are sold. The usual 5-member board could require that as, say, for example, 25% of the lots are sold, 2 members of the new community must be on the board. It is imperative that new residents be on the board so that the developer, who does have fiduciary responsibility for their actions, honor their responsibility, and that the residents have greater transparency to actions by the board that most likely impacts the residents financially. And I know this from being a member of the board for a Metro District at Wild Point. On more specific observations, I do question the need for a $70 million maximum limit on the issue of the general obligation debt. The $70 million proposed bond issue for a subdivision of 126 homes is $376,000 per house to be built out for the infrastructure. The probable construction cost in Exhibit D shows an estimated cost of the public infrastructure of about $44 million, and that value includes a 10% contingency. I realize that the estimates were done by the engineers and are not actual bids for construction contracts based on final plans. That there is a cost associated with the bond issue, and that there are administrative costs for the Metro District. But such a large bond maximum above forecasted costs seems excessive. In Section 5, Items 9 talks about fees. The plan reads, the district may impose and collect fees for services, programs of facilities furnished by the district, and the district may from time to time increase or decrease these fees. The district may use the revenue from fees for the payment of operations and maintenance costs and the payment of the debt. This seems to me a way to circumvent the debt fund 65 mil levy cap to cover the debt of the Metro District. The district already intends to implement a $35,000 tap and facility fee per house. My question is, what other fees would they foresee in the future? And you talked a little bit about that. Finally, the plan also reads, it is anticipated that the developer will advance funds to the district to pay for the operating costs until such time as the district has sufficient revenue from its operation and maintenance mill levy, which is what Jim Marshall just talked about. The developer should be authorized to reimburse the developer, or the Metro District should be authorized to reimburse the developer for such advance with interest. My question is this: at what rate is the developer reimbursed for these developer advances? As the interest rate is typically set by the Metro District Board early in the Metro District timeline, the developer often only has their people on the board, as no houses have been constructed or sold yet. I propose that the service plan define the interest rate the developer can charge the Metro District, and that the rate be based on a published federal rate, such as the prime rate, plus a premium for the added risk. Thanks for your time. Any questions or observations?
Thank you.
Thank you.
A few things here. We didn't show it in any of the slides or talk about it, but because we do anticipate that we'll be maintaining roads, we will be setting up a reserve, operating reserve fee for roads, and also probably for water. We have that at Spring Valley now, and those fees are paid by the builder when they pull permits. The reserve fees are going to be pretty significant, and we've implemented those at Spring Valley. We started about 3 years ago when we realized we were probably not going to be getting much road maintenance from the county. And honestly, the reason I did it at Spring Valley, the primary reason, wasn't because the county was talking about, not back then they weren't talking about not accepting roads. I look at your budgets. I see how much money you've got. And I drive the roads in the county as much as anybody these days. And you don't have enough money to maintain the roads you got. And the last roads you're going to maintain are the roads inside my subdivisions. So we need to have the reserves, and we need to set them up, which we are doing. And again, I didn't mention that earlier. The other thing is these roads are public. Brad mentioned that they're private, or they feel like they're private. They're not private roads. They are public improvements. They're public roads. The district is a municipal district. It's quasi-municipal, but it's a municipality just like Elizabeth is or anybody else is, and we have to operate as such. We have transparency. I want to touch on that again. We have a website. We advertise everything we do. Our budgets are online. Everything's online. Anybody that has a question can call us anytime they want. We have a professional management company. We've got our attorneys. I'm always available to talk to homeowners. Some of you guys know that. And it is a public entity, and we do have a fiduciary responsibility to keep our homeowners informed. Getting homeowners on boards, it's like pulling teeth sometimes. I've approached people to get on the HOA board, or not the HOA, but the Metro District boards, and it's tough to get people that want to serve on them. I've got boards that I'm on right now that I want to get off, and I can't get off. And we have to advertise the vacancies every time there's an election. We have 5 seats, and they're 4-year terms, but they're staggered. So every other year we have at least 2, maybe 3 seats available, and that's the time when the homeowners can get on the board. And the state's thought this through. This is not, this isn't the developer just saying, hey, I don't want anybody on my board. We have to follow the rules, and we do have to advertise the vacancies, and if there's interest, we get them on the board. This past year, Spring Valley Metro District number 2, we had a couple people interested in getting on the board, and we got them on the board. That's how it worked. I think, and like I said, I've got homeowners on every board out there except for the board that doesn't have any homeowners yet. So, there's, let me see, what else did Brad say? Oh, he mentioned Murphy. The Metro District up there with Murphy Oil and the potholes, that was not a Metro District obligation. That was a Murphy Oil obligation, but it was a problem. And I just happened to sit on that board. It's the Elizabeth 86 Commercial Metro District. And we made a decision to fix those potholes, which we did. They were fixed last week. I actually drove over there today to make sure. And I guess, it was last week they were fixed. But that was a Murphy Oil obligation. But have you tried to get a hold of anybody at Murphy Oil lately and convince them they need to go fix a pothole? And they were bad potholes, really bad. So just for the record. Let's see, service plan fees. Yeah, again, there was the reference to fees in our service plan. Those are fees that we charge the builders. We can't just arbitrarily go out and say, hey, you know what? We're going to throw a $2,000 fee and tell every homeowner they got to go pay it. The fees we collect are the reserve fees. They're the facility fees. They're the system development fees, which is another term for TAP fees. But all the fees are paid by the builder when they pull building permits and COs. Those fees are not charged to the homeowner. The homeowners pay for them. Of course they do. The cost of the house includes all those costs. But those are upfront fees. And interest rates. I don't disagree with Brad. I mean, I know there's districts where developers have taken advantage of the interest rate deal on developer loans. I don't do that. In fact, I'm usually below market because I don't want to be criticized for collecting exorbitant interest rates. I usually go below market rate. And that's true in every district that I've got, which is about 40. Any other questions?
Any questions, sir? Any questions?
Yeah, one more real quick, Jim. Reserve accounts, you talked about establishing those reserves for roads or for water. Do you have any targets that you like to try to hit, and we need this much in reserve, and can you explain that, and are you contractually obligated to have those accounts?
We're not contractually obligated, but it's the right thing to do, and it's the fiduciary responsible thing to do. We know that when we've got long-term maintenance, that these districts are going to be here in perpetuity. They need to be here in perpetuity. And the district needs the ability to refund those bonds, and I'm glad you brought that up. First of all, I'll answer your question. On the reserve, we generally will do a rate study, and we'll put a study together that says this is what we think we're going to have to replace. When we replace it, and how much we think it's going to cost with an inflation factor.
What's that study called?
We call it a rate study. Rate, R-A-T-E. And, I guess you could call it a rate and reserve/impact fee study. We're updating it right now at Spring Valley. And the reserve fees to the builders are going to go up significantly because of it. And you should review it probably every 2 or 3 years, just because things change, costs change, inflation changes, interest rates change, everything. But, the other thing is Brad's concerned about homeowner control. I think the district Brad sits on is homeowner controlled now. Maybe it took a little longer than it might have, but the bottom line is we have our bonds. I've never issued bonds yet on any district where the call protection has exceeded 5 years. And what that means is when my call protection burns off, I can refund those bonds to get lower interest rates. I can usually get some kind of rated bond deal. When we issue our bonds, and it's not unusual for any metro district, when we issue our bonds out of the gate, those are non-rated. We can't get a rating when we have no AV and we have no homeowners. But when we refund, we can get a rating, we've got homeowners, we get lower rates. I've got 5-year call protection on every one of my bonds, and we usually refund close to that 5-year period, usually within a few months of that 5 years, because we can usually knock at least 1 point to 2 points off the interest rate. And that's material. That's a material savings for the homeowner, creates more bonding capacity for the district in the long run, which is important for any district in Elbert County, because these districts are going to be maintaining things. And they are going to have to reissue debt someday. But the good news is they will be homeowner-controlled boards, and they will be issuing bonds in a rated arena, not a non-rated arena. And again, I mentioned earlier, I had a couple of refundings we did when rates got ridiculously low a couple of years. One was at 195, one was at 235. I mean, those are unheard of rates. Probably never see them again. But obviously we want to get the interest rates down as quick as we can. And as far as developer reimbursements, yeah, we loan a lot of money to districts. And guess what? I don't get most of it back. I get some of it back, but I never get it all, ever. And I write it off. That's what I do.
Just to follow up, so a rate and reserve study, could that possibly be done to tighten up the service plan?
No, it can't, because the service plan is, we don't know much at the service plan level yet. We don't even know for sure what our construction costs are going to be on a, we got to drill a well. Okay, it's probably going to be, we'll probably drill 2 wells out there. Last year, the cost to drill and equip and power up a well with pump and motor was about $1,250,000. Is it $1.5 million this year? I don't know yet. So we're kind of shooting in the dark, and that's not what the service plan's about. The service plan is about setting up the parameters for which we can issue debt, putting the cap on the debt mill levy, outlining all the powers of the district, and meeting the statutory requirements of the state. The bonds are where we actually tighten everything up, and we figure out how much debt we can really afford to issue. And it's always a 30-year bond. Usually it's a 30-year bond. And so, yeah, you really can't. The service plans are meant to give us enough latitude to do our job and get our infrastructure built with parameters that are protecting the homeowner and that are fair to the developer.
Anything else, sir? All right, thank you. Thank you, sir. All right, at this time, it's time for BOCC decisions. So is there a motion to approve or deny the service plan?
Mr. Chair, I move that we approve the Pine Ridge Metropolitan District Service Plan as presented.
Okay, is there a second?
Yeah, I'll second it.
All in favor, sign of aye.
Aye.
Aye. Motion carries. At this time, I'll entertain a motion to close the land use hearing.
Chair, I move we close public hearing on Pine Ridge Metropolitan District Service Plan.
Second.
All in favor, aye.
Aye.
Motion carries. Motion to adjourn.
I'll make that motion.
Second.
I'll make a motion to
Is
adjourn.
there a second?
Second.
All in favor, aye.
Aye.
We're officially adjourned. Thank you.